Good afternoon, members of the media, wider audience, public of Trinidad and Tobago, both listening and viewing. Welcome to this week's post-cabinet media press conference. I have with me here today two of my colleagues, the Honourable Attorney General and the Honourable Minister of Health. And without much further ado, I'll pass this over to the Minister of Health.
Good afternoon, ladies and gentlemen of the media. An issue that was raised before the Joint Select Committee yesterday dealing with HIV/AIDS and children. In that regard, I think it is incumbent upon the government to alert the general public through the media what this government is doing as far as its HIV/AIDS agenda is concerned. By way of background, Trinidad and Tobago has signed on to the UN AIDS twin goals of hopefully eliminating HIV/AIDS by the year 2030. One milepost on the way to 2030 is the issue of the 90-90-90 targets to be met by 2020. So I know I'm quoting a lot of figures. So milepost one, global eradication of AIDS as far as humanly possible by 2030. To achieve the 2030 target, UNAIDS has set a goal that by the year 2020, which is just a short 3 years away, that 90% of all persons with HIV should know their status. So, for example, if you have 100 people with HIV or AIDS in a country, 90% or 90 of those 100 persons should know that they are HIV positive. As we cascade down, then 90% of those 90 people should be on antiretroviral drugs. And then the third 90% of those who are on antiretroviral drugs, because they are on antiretroviral drugs, should have their viral load, that is the number of replicas of the HIV virus in a unit of blood, suppressed down to a level to make it undetectable or what is then considered to be HIV-free. And Trinidad and Tobago, as many countries in the world, have signed on to those targets. This came into the forefront yesterday again, when it was revealed that I think 5 children are in fact HIV positive, that may be due to risky behaviors of one type or another. Cabinet today and for the past couple of weeks has been deliberating over the procurement of machinery, software to track this epidemic and to make sure we adhere to our 90-90-90 targets by 2020. Today, I could tell you that Cabinet confirmed a Cabinet note of last week where $7.7 million will be spent on software system called SELMA, which will help us in tracking, analyzing data as regards HIV/AIDS, because without data, you do not know the size of the problem that you have. So I'm happy to announce that Cabinet has in fact approved $7.7 million for us to maintain and keep and procure into the future the software system called SELMA, which we have been using, but which we have to keep on using into the future. In addition to that, Cabinet last week approved $9 million for the purchase of 2 viral load testing machines. If we just back up to put this in context, you'll remember I said 90% of those people receiving HIV therapy should have their viral load so suppressed as to make them relatively what we call HIV-free. But you need machinery to test that viral load. So Cabinet last week approved $9 million to be spent on 2 extra viral load machines, which will go to the Medical Research Foundation at the Queen's Park, Savannah. because they are our major testing site. So that is some of the positive developments that the government is engaging with as we continue to get a handle on the HIV/AIDS situation. Before I close off my comments on that and take your questions, I think it is noteworthy that Dr. Courtenay Bartholomew is resigning his position as head of MRF. He is now 85 years old. And I think the country owes Dr. Courtenay Bartholomew a debt of gratitude. And I want to publicly thank Dr. Bartholomew for the excellent and pioneering work he has done in Trinidad and Tobago, and may I say globally, because he is recognized globally as an expert in HIV and AIDS. And to welcome his successor, Dr. Edwards, I believe. Dr. Edwards has been working alongside Dr. Bartholomew for a very long time. So Dr. Bartholomew leaves the foundation in very good hands. So, as I said, the Joint Select Committee brought this issue into focus yesterday, and this is just for me to share with you what the government's proactive response is to HIV/AIDS. Thank you.
Thank you very much, Minister of Health. And now the Honourable Attorney General.
Good afternoon to everyone and to Trinidad and Tobago. I come before you this afternoon, post-cabinet-wise, to introduce some work that has just been approved by the cabinet. In particular, a batch of legislation was taken to cabinet for its consideration today, and some of it has been approved for discussion now, and I'm pleased to introduce that today we have approved for movement onto the Parliament table amendments to the Bail Act, which is entitled the Bail Access to Bail Amendment Act 2017. We are specifically also going to introduce the Indictable Offences Pre-Trial Procedure Bill 2017, and we're also going to introduce a very important piece of law called the Criminal Procedure Plea Discussion and Plea Agreement Bill 2017. And we're also introducing the International Financial Organization's Corporación Andina de Fomento Bill 2017, which is to facilitate certain borrowings. I propose to deal with each of these in turn. I think we could start with the topic of bail amendment. As you would know, the government entered into an exercise of estimating the state condition and population characteristics of our prison system, both for convicted prisoners and, more importantly, for remand prisoners. The position of remand is, of course, that you are in pre-trial detention, you're awaiting your trial to come up, and the last figures, and I'll just round them off, show that we had approximately 2,242 odd people in remand. Of that number, approximately 1,000 of them were in remand for non-bailable offences, specifically for the allegation of murder, which is a non-bailable offence. But of the 1,242 odd persons who were actually in remand, nearly half of them had been granted bail by the courts, but simply could not come out of detention because they couldn't access bail. We undertook to look at this very seriously, and the Cabinet has approved today an access to bail improvement, because of course the allegation is that the state and condition of our prisons can reduce your chances of coming out a better person, and therefore the recidivism aspect is a very real one. In making sure that you ease the burden in the prison population, but equally facilitate what has already been granted by a court, which is someone's liberty pending their trial, we've brought forward a bill which proposes that you can actually use certified checks and cash, and that can be paid into the system, and I say system because it can be done at court and also at the prisons itself on every day except a Sunday and a public holiday, so that you can facilitate the movement out of the remand yard for people who have been granted bail by the courts. Now, this is a very important aspect of our societal operation. It runs alongside with our operationalization of electronic monitoring, as well as the discussion which is being had with the judiciary on estimating persons who have passed maximum sentence and who ought to be considered for conditional release, because their trial time has just simply outpassed the maximum sentence which they would have otherwise gotten if they had had a trial earlier. So looking at this whole aspect of your criminal justice system, a very important measure is the improvement of the access to bail. I'll just explain a little bit further on that there's an allegation and there's a statement that there's almost an underground element to the manner in which bail is procured. There is the phenomenon of what people refer to as professional bailers, because the magistracy has sought to opt to one version of bail only, which is the production of a deed to a property. And most people who find themselves incarcerated are in there because they simply just don't own property. They don't have access to deeds. So it's almost an impossibility for certain people to access bail. Sometimes the amount is, let's say, $30,000 or $50,000 or $17,000, whatever the amount may be. That's usually taken on the back of a deed, which must have, as they call it, value on it. So in the event that somebody doesn't turn up for trial, that the court has access to the property in forfeiture, essentially. I'm putting it in very simple terms. What this allows is for the placement of cash or certified checks into the judicial system, into the system of receivers, including facilities which will be put in place at the prisons themselves. And so this is a very important aspect of how we deal with our criminal justice system. Let me turn to the next item, which is the aspect of Criminal Procedure, Plea Discussion, and Plea Agreement Bill 2017. This particular bill is one which intends to repeal and replace the existing law, because there is already existing law which was passed in or around 1999 to deal with plea bargaining. The plea bargaining was intended to bring to Trinidad and Tobago a system such as exists in the United States or elsewhere, where almost 95% of matters don't go to trial, because you have the opportunity to know what your maximum sentence might look like and arrange a discussion, an appropriate discussion with the prosecutors involving the judicial authorities, and therefore you strike a bargain within due process, as is done in many countries around the world, to therefore ease the need to have an actual trial. Now, the existing law has a terrible track record. In fact, the statistical analysis on it shows that only 12 cases have actually resulted in plea bargaining, such that people avoid a full trial. The work which comes before us has been driven by a combination of efforts, and largely from the criminal bar itself. The deficiencies which were identified in the current law included whether it applied to indictable offenses. There was a certain amount of ambiguity in plea discussions. There were limited incentives to prosecutors to offer persons because there was a potential of being caught by an improper inducement allegation. There was definitely some confusion in relation to what constituted a plea agreement. The failure of inclusion of the victim's perspective was a very material deficiency, because you can't certainly only consider the rights of the accused or the position of the accused. You wanted to know how families felt about it, how persons who were affected by the crime felt about it. You wanted to know who was an appropriate relative to be considered. You wanted to know whether there should be greater judicial oversight. The system which we're bringing to Parliament now proposes that a plea bargaining process can begin even prior to a charge being offered. So the legal minds get involved in the equation even prior to the issuance of a charge. That allows for a discussion to be had between the persons who indicate that they wish to prosecute if a charge has not yet been laid, or persons who are prosecuting if a charge has been laid. You have the discussion, you get all of the inputs, including your victim input. You take all of that to the judge, who then hears the matter and deals with the appropriateness with a complete power to say yes or no as to whether a bargain ought to be struck, a plea bargain ought to be struck. This system potentially has dynamic consequences, important consequences to our criminal justice maneuver system and backlog. 95% of cases in other jurisdictions that use similar models do not go to trial. And in looking at how we get people to meet the courts to suffer consequences that they should suffer if a court says so, you have to look at how you're going to process the cases which are already in the system, as well as process the cases which are expected to come to the system. I should tell you that very shortly, I'll be coming into the public domain to indicate what the real backlog looks like. The backlog will be disaggregated from cases which are 1 to 5 years old, 5 to 10 years old, and those which are 10 years and more in length of awaiting a trial to come up. What we have done in the bar, bench, executive, and criminal justice advisory team, which includes the Honourable Chief Justice, members of the Court of Appeal and High Court benches, the members of the Criminal Bar Association, the DPP's office, the Criminal Justice Advisor, which is sponsored by the Canadian government and the British government, and the executive arm, which is the Ministry of National Security and the Ministry of the Attorney General and Legal Affairs. What we have done is to go and check the actual files. And what we found out is that the number is not as large as it was reported to have been. In fact, the number has reduced significantly, almost halved, because what we've done is to actually check the files themselves. So whilst we are promoting law of this type, we have been doing it at the same time that we've been analyzing what the real situation is. You see, the ultimate intention is to be able to accelerate the trials. Now, this has a significant consequence to crime and criminality, because the position in our country must be that you promote, if you do the crime, that you should do the time. The gap which has to be closed is the length of time between a charge and an actual conviction or acquittal. And this measure of plea bargaining and these measurables are directly associated to that. The third bill that I'd like to tell you a little bit about is the Indictable Offences Pre-Trial Procedure Bill 2017. This bill will deal with the very messy situation that we have in Trinidad and Tobago. A preliminary inquiry is a step in our law where someone who is accused of having committed a crime is brought before a magistrate so that the magistrate can consider whether there is sufficient evidence to take that matter to the High Court for a trial. After that process of preliminary inquiry, you go to the High Court, which is what is referred to as the assizes. When you're in the assizes, you then go on appeal. After appeal, you can go to the Court of Appeals. After the Court of Appeal, you can go to the Privy Council. There is, however, another route of law which can operate in that process. After the preliminary inquiry is heard, it is open to a defendant to challenge the decision of the magistrate for the committal to go to the High Court on judicial review. That judicial review goes to the High Court, then to the Court of Appeal, then to the Privy Council. It may or may not go back to the magistrate, and so you therefore got two concurrent systems going. Let me translate that to a case in point and in fact. The largest allegation of corruption in Trinidad and Tobago in terms of quantum of a case which is very old is the Piarco Airport inquiry. That Piarco Airport inquiry shows that an airport which is built in 1999, 2000, has a preliminary inquiry which is still going on in 2017. So the preliminary inquiry into the Piarco Airport inquiry is 17 years old. After the 17 years are finished, you then go to the High Court if the magistrate says that there's a case. You then go to the Court of Appeal, then to the Privy Council. But before you get there, it's open to the lawyers for the accused to consider whether they wish to take judicial review and go to the High Court, Court of Appeal, Privy Council, and then come back. If you look to the management of allegations in that particular case in foreign jurisdictions, trials have long since come and gone. Persons have been incarcerated and released. Assets were forfeited already. Some of them were repatriated to Trinidad and Tobago. So that's what preliminary inquiries means, and that's a case in fact. The law as it currently stands is that there is a Preliminary Inquiries Act, Chapter 1201. But you will recall that the last government passed Act number 20 of 2011. It was the Administration of Justice Preliminary Inquiries Act. And then Act number 14 of 2014, which was essentially to introduce paper committals. What they did was to go through a route, which was an experiment in other Caribbean jurisdictions, of having a paper-based position and move it from one court to the other. What we propose and what is contained in this bill is that you completely abolish preliminary inquiries. You completely abolish it and you allow for the Director of Public Prosecutions to decide whether a matter is to be heard summarily or indictably. Simply. There's no more that ground of considering whether there's sufficient evidence to go forward, because the DPP will consider the sufficiency of evidence. And then the matter will go to the court for consideration. And of course, there's full due process in that system. You stand before whichever court it is, be it the summary courts, which is the magistracy, or under the indictable route, the High Court, and you have your trial there. This is a very important bill to deal with the delays in our criminal justice system. You must remember that this applies across the suite of criminal charges. All criminal matters currently exist under preliminary inquiries. But the country is in a very untidy state because you've got Chapter 1201, which was the old law. You actually have Act number 20 of 2011, and you have Act number 14 of 2014, and you had the 2012 position where the repeal of Section 34 was done. I think the country remembers Section 34 well, and the trip to the Privy Council and back. So this particular piece of law is of extreme importance in dealing with the criminal justice system. I should tell you that there are other bills which the Cabinet has referred to the Finance and General Purposes Committee, which sits as a subset of the Cabinet, which are also related to the criminal justice improvements. And those will come to you at a later date after Cabinet has considered, if appropriate, that it should so come. And very importantly, whilst we're talking about the technicalities of law, I'll remind you that we're doing a significant amount on the operational side of the law, because we are measuring what real backlog looks like, the provision of personnel to the Office of the Director of Public Prosecutions, the creation of a public defender system, the use of DNA evidence by employing a custodian for the first time. Cabinet will consider very shortly the taking of DNA evidence to build the database, which currently stands at an estimated ability to be done within a six-week time frame for the entire prison population in Trinidad and Tobago. We are also operationalizing the electronic monitoring system. And so there's a whole package to deal with the criminal justice side of this equation. And this is just some of the material that is coming. The last bill that I wanted to refer to is the International Financial Organization bill, which is to deal with what is referred to as CAF, the Corporación Andina de Fomento, which is the Andean bank position. It's to allow for borrowings from that bank. You see, that bank was accessed by the placement of a lot of money by the last government, but the enabling legislation to allow for the borrowing from the bank was not done. In this particular time where borrowings are essential to the government of Trinidad and Tobago to meet its financial situation, moving this particular bill is of extreme importance to the country, and so we're very pleased that the Ministry has been able to bring this forward and that the Legislative Review Committee has done that. There is a lot that can be said around all of this. I'm sure that you have multiple questions, and subject to anything that the chair of these proceedings may want to introduce prior to question time, I'll rest for your questions.
Okay, thank you. You all have heard from the Honourable Attorney General as well as the Minister of Health, and as is usual with our format, I'll invite some questions at this stage.
Could you indicate, you mentioned, we were talking about revelations from a JSC yesterday. There was also the revelation that for the last, from 2014 to present, you have a very serious level of lead contamination coming from the Guanapo landfill into the system, the general water system via carrying. Now, you're not the line minister for that agency, but as the Minister of Health, is this a situation that concerns you, and is this a situation that will see some sort of collaboration between your ministry and public utilities to, say, get a better assessment as to what the problem is, how long it's been happening, why it's been happening, and how you treat with it?
I will step in, although you've directed that question to the Minister of Health, and the answer is yes. As a cabinet, we've asked for a report, an urgent report on this, because we saw and listened very carefully to what took place yesterday. The Ministry of Health will play a vital role in that, as is to be expected, at the appropriate time. So right now, we've asked public utilities to produce for us a very urgent report on the situation, because as the government of Trinidad and Tobago and all of our different facets, we are very concerned about what we heard yesterday.
Did the Public Utilities Minister know of it? Any of there was a Public Utilities Minister before.
Well, as we heard yesterday, yes, it is something that was in 2014, I think, is the timing that we've heard. So now that we've seen it, we are calling for a report on it at the cabinet level.
Minister of Public
It was not before us, so it is something we're going to look at.
Never raised the issue before.
As I say, it's something we now call for a report on, and we will be looking at.
How soon do we expect to get that report?
I would hope within a matter of weeks.
But in the meantime, there is still the issue of potential lead poisoning in the water. So,
well, we heard what we've heard very clearly yesterday from what I've seen in the media reports is that is what the persons who were in charge, i.e. SWIMCOL, were saying. So if they have this information, then it should not take us long to get in there to deal with it. I'm sure we will then set up a committee to come back to us with the recommendations as to how it should be addressed, because it is a very serious concern from a health perspective as well as an environmental perspective.
Just to add into this, you must appreciate that it's historical information. The reports have to come carefully, but it's much more than just Ministry of Health and Public Utilities. The ministry with responsibility for the environment, which is the Ministry of Planning, the Ministry of Rural Development, Local Government, and the Ministry of Energy have certainly roles to play inside of this, because inside of landfill sites is the waste to energy, the recycling, the mobilization of SWIMCOL, etc. So there are multiple aspects of this. I think I would be comfortable to say that if one took a decision immediately to stop utilization of site, for instance, that you can't solve the problem just like that. You would literally have to get to the source of contamination and deal with it in a very comprehensive way. Fortunately, this is not a novel issue globally. I'm sure that once the report is had, that the very best efforts will be taken with immediacy, and that the cabinet will be apprised of it in a very, careful fashion, because we've got to plan this thing right. There's a logistical arrangement to all of this. You have to move the fill. There may be treatment aspects. You have to consider where it goes to. You can't just move a contaminant from one site to another site. So the logistical arrangements have to be properly planned into this.
But in the meantime, would you all advise the population not to drink water?
First of all, I don't want us to overreact or underreact. So we really have to wait for the report, because yes, it has been said, and what I read in the newspapers this morning and some of the commentary going to and fro between the members of the committee as well as swim call executives, is one of the questions that came to my mind immediately is it affecting any aquifers that are being used or utilized by the public? Is there any risk that this has actually seeped into water that's being consumed by the public, as opposed to testing that is taking place? And you would expect that there's testing taking place at landfills and this type of thing. So the first question that came to my mind is, how does this affect the public? Has this gotten into water contamination of water that is utilized by the public? And I don't want us to venture anything at this stage, because I quite simply don't have the facts in front of me. We at the Cabinet don't have it, but I can tell you it is of concern to us, and we are working on it immediately.
Maria's question, which will be on TV6 News, is the government in a position to give any advice with regard to the issue of the consumption of the water supply?
Well, Jule, first of all, you have a number of bodies. We have SwimCall. The next body that's in charge of providing water and sewage facilities for Trinidad and Tobago is WASA. So I would want to get a report from both of those bodies, and answering the question I've just asked coming out of what Ria has said. Has the water consumption in the area, nearby, far away, anywhere, been contaminated, and water that's being utilized by public? And quite simply, we don't have those facts as yet. So we can't, it doesn't make sense even venture anything until you know those facts.
The Cabinet at least, or will be asking questions of SwimCall or the Ministry.
Absolutely.
In terms of how this information sat down since 2014.
Absolutely.
And why is it now coming to light in 2017?
Absolutely.
In the meantime, and going forward, what does the government have in train for those dumps?
That conversation has come up at previous cabinet level and at the FNGP level, and we are waiting on some expert reports. We had actually put in place a committee to take a look at it. As you heard the Attorney General say, it would fall under the Ministry of Local Government and Rural Development, the Ministry of Energy, because we want to know on these landfill sites whether there can be the utilization of renewable energy sources and resources and these various bodies. So a committee was put in place to look at consolidation of waste, utilization of less sites, where's the best place to have a site, what can be done from a renewable energy point of view. And of course, now with this going on, we would also want to know, as the Attorney General has said, if we're going to disband the use of sites, what are the effects to the environment, and how can that be reversed or contained at a minimum?
I have a few questions. Two questions for the Health Minister and one for the AG. You mentioned SELMA. You said that the money is going towards us continuing using this software. In what year did we start using this software?
Excellent question. We actually purchased SELMA in 2007 from a company called Terida. Terida unfortunately went bankrupt in 2013. And the software owner who held the license reverted to a company called Riomed. And from 2013 to now, we have been actually dealing with Riomed on a month-to-month basis, which was not satisfactory. So that is what we are now correcting, to go with SELMA and Riomed on a more permanent basis. However, going forward, the Ministry of Health is collaborating with both PAHO and CDC to get new software in about 2 years. So that's why I said this 7.7 million is to take us into the next 2 years and to pay outstanding bills. Because the software integrity has changed over the past few years, and PAHO and CDC is working with us for a more robust system moving forward.
Okay, and you also mentioned that the $9 million is for the purchase of 2 extra viral load machines.
Correct.
How many do we already have?
We currently have 2 in the country, but they are quite aged and should have been replaced about 4 years ago. So as we gear up to commit to our goals of 2020 and 2030, we have to replace those machines or possibly recondition them whilst we bring in 2 newer machines.
Mr. Al-Rawi, with respect to the Access to Bail Amendment Act, are you worried that now making it easier for people to access bail through cash and checks will allow for financiers of crime to perhaps bail out their friends?
Obviously, there would be a concern on both sides of the equation. The fact is that the analysis of the consequence of long remand positions has multiple dimensions. I have said to Trinidad and Tobago in public consultation that there are examples of people who have not paid a parking ticket, who have small quantities of narcotics, meaning marijuana, who have failed to pay maintenance or a fine of $12,000, for example. One case, there was a fine of $12,000 and you were incarcerated for 1 year. So on that side of the equation, there is an allegation that you could be creating criminals. Because when you look at the condition of remand, and you look to the judgments of Madam Justice Gobin or the Inspector of Prisons report produced under the hand of Daniel Khan, you realize that work has to be done, and I can tell you work is being done on the remand condition. In fact, I'm very pleased to tell you, the Ministry of National Security and the AG's office, we have been in close discussions with the Canadian government. The commissioner head, as he's referred to, came to Trinidad and Tobago from the Canadian Corrections Department, and we are very busy about doing the reform of our prisons population condition, including the physical architecture, the mechanisms that exist for how we manage our prison population, case management software, etc. So that's on one side. We're fixing operationally in the middle. On the other side, the allegation that people could be let loose by their financiers, this has to be put into the context that a judge of the High Court or a magistrate has granted bail, and it's an existing permission to get out. It's just being hindered by the fact that sometimes very poor people just don't have land to offer into this equation. If there is suspicion and objection to bail, then there is a process to deal with that, where the state can object to bail. That's why the other exercise on the operations which is going on is so important. 95% of prosecutions are dealt with by the police, 5% by the Director of Public Prosecutions. I'm very pleased to again remind you that we are working with the Commissioner of Police, doing the snapshot of how the cases are managed, so that you know who is going to be in court, what day, is the case ready, are you ready to object to bail, have you done your antecedents, are you ready for record discovery, etc. So there's a balancing act for sure. We believe that this is the correct approach to move to because it facilitates what a judge of the court would have ordered, and that's the important point.
I understand all of that, but typically someone who hasn't paid a parking ticket is not a member of some criminal organization. And is the judge then going to be able to screen how clean that money is, or the checks rather?
Of course, but let me ask you a question. Right now in Trinidad and Tobago, how do persons accused of very serious crimes pay their legal fees? How do we screen that? How do lawyers receive money? Where are they? That's another conversation that we're having as well, you know. You see, the proceeds of crime and the facilitation of certain issues are being examined by us in multiple dimensions. This is why we are working on many packages of reform, some of which we've spoken to in the public domain already. So what I can tell you, each and every bill that comes forward has to be measured on what's before you. Not speculation, not hyperbole. You have to have actual facts before you, and then you assess it, which is why, whilst we give the signal of what is to come, when you see a bill like this and you assess it, you then look to the degree of consultation, you look to the merits and demerits, the pros and cons from a jurisprudential perspective, and then you deal with the situation. A lot of what we're dealing with right now has not been dealt with for years. And the criminal justice system is creaking and breaking, and we have to fix it.
So my last question for the AG. Now, while I agree with you that preliminary trials tend to, preliminary inquiry rather, drag out the justice system, the whole process, and cause all these delays, are you worried that certain lawyers will put out of business those who make their money on preliminary inquiry?
Let me give you some information which you may not know. One of the delays in the criminal justice system is what you call counsel of choice. An accused comes before a judicial officer and the matter is called and the accused says, my lawyer is not available. My lawyer has other matters going on. When asked as to how many attorneys really control the criminal bar, the number is really close to about 20 lawyers that have the vast majority of cases. When you look to 1,000 people in remand for murder alone, and you spread it across 20 lawyers who control the vast majority of cases, you got to ask yourself, well, how often are these lawyers going to be available at the same time for matters? Which is why we're working on the development of competent counsel. And I can tell you we've met already with the director of the Legal Aid and Advice Authority, and we're looking to build out what you call a public defender's place. So if your lawyer of choice is not available, you will be provided with competent counsel to represent you at trial. Whether we put lawyers out of business, there's always room for good lawyers. Lawyers can do well. There is a lot of systemic work in Trinidad and Tobago. If you look to the judicial statistics, in the magistrates' court alone, there are 142,000 cases a year brought to the magistrates' court, let alone the 5,000 divorces which come, let alone the civil trials, let alone the criminal trials. So there's a lot of work. I'm not concerned at all. What I'm concerned about, and this government is adamant has to be fixed, is that there has to be a closing of the gap between charge and conviction. Otherwise, it's worthless. So the attempts before us with the legislative specific proposals before us now are to close that gap so that you really feel that you need to think twice about doing something, because chances are you'd faster suffer the consequences in a new system.
Minister of Health, could you give us some numbers with respect to HIV, in terms of percentages over the years? Sure. And also, this picture of this lady without clothes having gone viral yesterday and a lot of public reaction. Would you have considered it to be a Ministry of Health issue, quite apart from it being a Ministry of National Security issue? Because if you have people like that walking about our streets, I suppose some kind of police or security and national security should kick in. Outside of that, if it is, as was reported, it's a mental health situation with the lady, is there a system, that the Ministry of Health would have that would kick in and help the situation?
Okay, so let me take your second question first. It is quite unfortunate what happened with that young lady. The Ministry of Health was kick in under the Mental Health Act. And the Mental Health Act clearly states that a mental health officer can take in someone who is wandering around in the public in a disillusioned manner. So there is that possibility. As it stands now, we have no facts as to the state of the mental health of that particular person, so I can't make a judgment call or a clinical call as to that person's mental state or mental health. What I will also say, and I think the AG mentioned this in another forum, it is unfortunate that social media profits from unfortunate incidents like these. And I think we are all our brothers and sisters keepers. We never know what another person is going through. So I would just urge everyone to be a little more conscious and aware and respectful. let me get onto the issue of HIV/AIDS. The number of persons estimated to have HIV in Trinidad and Tobago is roughly 11,500 persons. That's the estimate. Of those 11,500 persons, roughly 73% of those are currently on HIV therapy, antiretroviral therapy. Now, the targets that we are supposed to be heading to by 2020 is 90%. So we have a gap of about 27% to make up. And then of those 73% who are on antiviral therapy, only about 50% of those, the last figure I had, actually have viral load suppression to the level that we wanted. So you can see where the gaps are. So you can see why it is so important that we make this timely investment into SELMA and into the purchase of the viral load machines. So I'm happy that we are taking this very proactive stance. It's a couple of years late, but it's about 3-4 years late, but we will try to make up for lost time.
Just 1 second. We wanted to wrap up by 2:30, so we'll just take a couple more questions. I think the Minister of Health also had something to say. So your last question, and then you'll give your friends in the media an opportunity.
Given the advent of Carnival, you're ramping up your notices or advisories to the members of the public.
Yes.
To be safe.
Yes, we are ramping up, and I thank you for that, because that leads me into the last say which I wanted to have. Fortunately, we are ramping up our messaging into 2 areas of activity that are heightened during the carnival season: HIV/AIDS, and we ask people to be responsible in their behavior, in how they conduct themselves, to use prophylactics as far as humanly possible. We will also want to appeal to people, don't get involved with intravenous drug use, because that is one of the key areas in which HIV is transmitted. But the other part of it has to do with the flu season. For members of the media who have been following me since I became Minister of Health about 18 months ago, I would have stood before you week after week and announced we had another death due to H1N1. And we've been having deaths in this country consistently since 2009. By this time last year, I would have stood before you and announced we had 6 deaths due to H1N1 or the flu. Because of the very rigorous vaccination campaign we have launched, I can tell you the figure for this year is 0. We have had absolutely no deaths due to the flu this year. Last year and this year. The flu season runs from October 2016 to May of 2017. So we are becoming the victims of our own success, in that because we are so successful now, the public is no longer rushing to get vaccinated. But we have in the papers, and you will see all of the newspapers, we are giving you equal treatment, full-page ads, asking you, because of Carnival and because of the influx of visitors from North America down south, this is the period, the most crucial period between Christmas and Carnival to get vaccinated. In the years previously, the vaccinations were limited to special groups: pregnant women, children, people with metabolic diseases. We have brought in 100,000 doses of vaccines, and we are now vaccinating anyone. So anyone, regardless of age, gender, whether you are pregnant or not, whether you have diabetes or not, you could be in the best of health. Please go into any one of the 33 health centers on Tuesdays and Thursdays and get your vaccinations free of charge, instead of paying between $300 and $500 in the private sector. We have had no deaths. Let's continue along that path. Get vaccinated.
Kamal, last question.
Minister of Health, as you were speaking, doctors at the Port of Spain General Hospital maternity ward have complained about what appears to be drug shortage. They said there are no syringes, no adequate antibiotics, and also things like basic items like toilet paper. Some of them are willing to go on the record. And I just wanted to get
I will certainly look into it. They have not contacted me on that, but I will certainly, when I go back to my office, have the the CEO look into that. If that is true, that is a very serious issue.
I mean, there are serious short, medium, and long-term repercussions of consuming lead. I know we've said we can't determine yet whether the aquifers have been contaminated, but in particular, children who consume lead, they are exposed to serious risk. So, as the Minister of Health, this time I wanted to know whether or not there is anything that you can caution.
The Minister of Health, where they have an issue of potential lead poisoning, I don't think there's a line minister. All ministers should be concerned, because this cuts across everything.
Kamal, I just want to go on record. Just let me make this point. So far, there has been absolutely no evidence brought to our attention
That's why I said potential.
of any lead poisoning taking place in the potable drinking water. And I think we need to be very careful with this. By now, because this was very heavily reported in the media this morning at minimum, if not last night as well, I would hope and trust that the authorities who are charged with the responsibility, i.e. WASA and other authorities, are onto this so that they can give us the citizens of Trinidad and Tobago, the assurance that there is no risk that this has taken place, or if there is a risk, that they have now propelled it to the other authorities, i.e. the Ministry of Health authorities and a whole of government approach as the persons who would have to put an immediate plan in action to deal with this. So the government is concerned, and everybody having heard this morning, I would be shocked and surprised if WASA has not already been in touch, and if SwimCall and others are not already working for us to firstly determine whether there has been any effect on the drinking water supply. All right. Thank you all very much, as usual, and we'll see you all next week. Thank you.